Hello, everyone. Thank you so much for joining us for another session of Talking to the Experts. We have a lot of ground to cover in creating your will and the importance of having a will. Our time together is very, very limited, so we're going to jump right into it. First and foremost, here's our presentation timeline. We'll be talking about the importance of having a will and a few cautionary announcements. First and foremost, anything you see in this video, please keep it in mind is for general purposes only. It is not intended to provide you with personalized legal advice, tax advice, or investment advice. If you're looking to seek advice, please reach out to myself or any of the other IG wealth management specialists or consultants, and they'd be more than glad to help you out for your individual cases. My name is Hash Assad. I'm an executive financial consultant as well as a division director with IG Wealth Management for the past 18 years. I have certain designation. One of them is a certified financial planner. That's the PN of my industry for what I do. Within IG Wealth Management, there's a lot of advisors, about 2,000 practices across Canada, but there's a select few of us who are qualified to be on the securities platform. I'm one of those, and I have the capacity not to only give you advice on mutual funds, but also stocks, SMAs, and other types of securities. We're fully licensed in the provinces of Alberta, BC, Nova Scotia, and Ontario. As you may know, it takes a team to do what I do. I have my associate consultant, AJ Saran, here with us, as well as Tanya Ochoa. She is our executive assistant. There's a professional team of accountants and lawyers and actuaries behind me with over 400 years of combined experience, depending on how complicated your situation gets. Keep in mind, we've recently launched our brand new website. If you haven't already done so, please go ahead, check it out, assadwealth.ca. Connect with me on LinkedIn, send me an invite. We have our Instagram as well as Facebook, Twitter, and of course, you can just Google Assad Wealth Management to see what our clients are saying about us. On a regular basis, what we do is we reach out to our clients and we ask them a very simple question. Rate us from 1 to 10 and leave any comments. Now, these comments are completely optional. They're not required to do this, but we're always blown away about what our clients are saying about us. My favorite one is this one right here, which says, Hash is very knowledgeable. We worked with him for years and he's done very well for us. His calm, laid-back attitude is a welcome relief in these very stressful market times. This is July of 2022. We're right in the middle of the most stressful time since we had since 1970s, actually 50 years ago. He's always available to chat, even if you don't have an appointment. But you can see all the different reviews and what our clients are saying on our social media platforms. So go ahead and check it out. IG Wealth Management has been around since 1926. It's one of the oldest financial firms in Canada. There's a lot of companies who do what we do, but what we are known for the industry is our sophisticated, interactive, comprehensive financial planning experience with over $122 billion of assets under advisement and access to some of the best institutional fund managers in the world. Today, we'll be talking about one component of financial planning, which is the importance of having a will. There's a lot that goes into financial planning, which is, starting from your retirement, optimizing, preserving your capital, making sure that you're able to share your wealth with the ones that you love and not Revenue Canada, managing your cash flow while you're earning income, but more importantly, when you retire and making sure that the income is coming in consistently and lasting through your life. Preparing for unexpected events, such as furnace breaking down or, having any medical issues. We want to make sure that if you're a business owner, that your business is optimized both for today and well into the future, and everything is done in the most tax efficient way possible with a written financial plan called the IG Living Plan. We're going to get going with our presentation today with an exclusive interview with Christine Van Countenberg. Christine is the author of Wealth Planning Strategies for Canadians, the book that's been published and well into its 16th edition. Christine is a member of the Canadian Tax Foundation. She has her certified financial planning designation as well as a registered retirement consultant and a trust and estate practitioner from STEP Canada. She has published numerous industry papers, including the Canadian Tax Foundation, Conference for Advanced Life Underwriting, the Law Society of Manitoba, and Estate Trust and Pension Journals. We're extremely happy and grateful to have Christine with us to answer questions about the importance of having a will and why should you have a will. Allow me to bring Christine on board. Hello, Christine.
Hi, Hash. How's it going?
I'm doing well. Thank you so much for joining us. I know you're extremely busy, but listen, I started this industry about 18 years ago. From my first day up until today, I've been consistently told that you should have a will, and it's extremely important to have a will. Can you please, basically explain to us what is a will and why is it so important to have one?
Well, a will is basically a statement as to how you want your legacy to, your assets to be distributed. And if you don't have a will, even though there is legislation that would dictate how your assets would be distributed, and in fact might operate in exactly the same way as a will would operate, depending on your situation, it does cause just a lot of uncertainty for families. And I find that there are a lot of families that, first of all, they lose a loved one,
Hmm.
often very unexpected. They're very stressed. It's very emotional. And then they're frantically looking around for a will. And, I, in every case, tell clients, like, what you really need to do is go see an estates lawyer and talk to them, and they'll tell you what you need to do and which forms to fill out, whether or not you have a will. But there are a lot of people who want to do it themselves, and they think that having this will is going to be, this really set, clear list of instructions, which it's certainly better than not having a will, but all it often says is, I leave my assets to my spouse or to my children or to a charity or whomever. You still have to do a bunch of other work finding what those assets are and, collecting everything. And so I think that sometimes people think that it's going to include more than it does. It is very important, but what it is sort of a roadmap for how you want your assets to be distributed. But there are a couple of other key reasons why you'd want to have, key things that are in the will. First of all, who's going to be appointed as executor, who's going to be appointed guardian as your children. You want to have the ability to make some of these big decisions yourself and not have a court or someone else make them for you. So it
Hmm.
really is a guiding document, but it's not the be all and end all in terms of your estate. There's other factors that could play into how your estate is distributed.
Excellent. So it's a guiding document to tell what will happen to your wealth once you pass away, essentially. Simplest way of putting it.
Yes, but the wealth that goes through your estate, you can have all sorts of your wealth go to your beneficiaries through beneficiary designations, sometimes even shareholders agreements, other things. There are many situations where people don't have an estate, and sometimes when I say to clients, "Oh, yeah, don't worry, the first spouse to die won't have an estate," they actually think, "Well, what do you mean? I've got lots of money." Yeah, well, you have lots of money, but you're having it distributed through joint ownership arrangements or what have you, and so there's nothing actually in the estate. So that's the other thing to keep in mind, that the will really only governs what goes through your estate. And if you've done so much probate planning that there's nothing in your estate, it might actually be completely irrelevant.
Interesting, very interesting. We have so many questions for you when it comes to the state with the will itself. So the purpose of the will itself, like I think you briefly explained that to us. Maybe we can dig deeper a little bit. Is to give directions in a situation where you do have assets that does not have a designated beneficiary, to give instructions to your loved ones or to the executor to do what you wanted them to do.
Yeah. I mean, first of all, the purpose of the will is to choose who is going to make those decisions on your behalf. So who's going to act as executor?
Hmm.
Because even when you're dividing things up, sometimes, are you dividing cash? Or are you dividing assets? There's still decisions that have to be made. So, are you going to sell things? Are you going to distribute them in kind? So you have to choose an executor. If you have children, you want to make sure that you've chosen a guardian. So it allows you to make, the purpose of the will is to allow you to make those decisions, again, as opposed to a court. It allows you to decide how your estate will be distributed, although there are some limitations. So if you're leaving dependents, and let's say you have young children and you decide to leave everything to a charity or something like that, your dependents could come forward and make a dependents relief claim. In BC, it's called a wills variation claim. So there's still the ability for people to challenge it in certain situations. So I don't want people to think that you have complete testamentary freedom, but the purpose of the will is to at least make certain key decisions and give some guidance as to the executor as to how you want everything distributed.
Excellent. Now, I think you briefly touched base on this, but I'm curious to know: is there specific, um, criteria that you suggest that listen, you should have a will like right now? Is there a specific asset level, family considerations? Like, where do you say, listen, we highly recommend if these criteria are met that you should have a will?
Yeah, I recommend that every adult Canadian have a will. I
Mm,
realize that may not, that isn't the case. We know from the statistics that definitely isn't the case. But I do recommend that every adult have a will. And, having practiced in estates law for getting close to 30 years now, I've seen, a whole bunch of tragic situations where parents have lost children. And so, you wouldn't necessarily think of someone in their 20s or 30s passing on. And those people might actually think, well, I don't have anything. Well, you don't have anything now, but if you passed away and you had insurance or you had other things, you actually, a lot of people are worth more after they've passed away than in life, which
mhm.
tragically, but you still need to give instructions to your parents and say, okay, yeah, you're going to act as executor. Please distribute it to so and so, because again, if there is no will, then the courts have to make certain decisions. So let's say hypothetically an adult child did pass away, the parents then, and there is no will, the parents have to go to court and file documents asking for permission to act as
Mm.
executor or administrator in that case. So it's that extra step and that extra hassle. They might have to post a bond, there might be some extra cost. So I think for a lot of people, just the additional hassle of having to go through a court process, even though it's not really a court process in the way that you might think of it from the movies. I mean, it's more of an
Yeah.
administrative process, but I mean, it's still, again, understand that people are in a state of heightened emotion. They're stressed. They don't know what's happening. Unfortunately, a lot of people try to do them themselves. It's frustrating. The documents get rejected. So, if you can avoid some of that and just give your family some clarity, it is helpful. So just as a general rule, I say all adult Canadians, and then that way you know that you're going to you have your bases covered.
So 18 years plus should have a will. Simple as that.
That's what I recommend.
Hey, listen, that's a lot less complicated than I was expecting it to be. As very honest. I think you talked a few different, you use a few different words in our conversation so far, executor, beneficiaries, and a few other things. So, who are some of the key people involved as part of your will, and any tips or tricks in terms of how you choose these people? Anything that we should look into avoiding, perhaps, when making these decisions?
Yeah, and that's a good question because sometimes people don't think about who they're going to appoint for certain functions or
Mm,
roles and don't even ask them in advance. And it is very important to ask people in advance if they would be willing to act as executor, if they would be willing to act as guardian. I know of situations where people have been designated as guardian, and fortunately, they found out before the person passed away. But when they found out, they said to the person, "Just so I don't want to be a parent. I'm not trying to be. I mean, I love your children and all
mhm,
that kind of stuff, but
mhm,
I can't be a parent for whatever reason." And I think sometimes I've had clients who've said, "Well, I'm going to choose so and so because they don't have kids." Well,
mm,
have you talked to so and so? They might not like kids. Sometimes they say, pick the family with 4 kids. You throw a couple more in there. Who's going to notice, right? Like they love kids. They've had 4. So, but again, it could be quite the opposite. The people who don't have children may, be super happy to get it. So you never know, but you should talk to the people in advance. Would you be willing to act as a guardian? Understand that this could happen literally overnight. At least
mm,
when you have your own child, you get 9 months advance notice. You're not necessarily going to get any
yeah,
advance notice. So,
yeah.
would you be willing to act as guardian? Would you be willing to act as executor? If you pass away and they're not willing to take on the role, oh my gosh, now we've got a stressful situation. Where do they live? So, particularly with executors and also powers of attorney, and I realize we're talking about wills, not powers of
Mm,
attorney, but
mm,
when you're doing your estate, a lot of people do the documents at the same time. Make sure they're a resident of Canada. In many cases,
mm,
people choose their children and then their children move to the States or in some cases Australia or wherever. And then the court says, well, we can't appoint them and, they have to live in Canada. Sometimes the court's looking for someone who lives in the province. So do they live close by? There could be tax implications. I've had some people say, oh, well, I'll choose so-and-so as guardian. I'm sure they won't mind moving back to Canada. And I'm thinking, they're not moving back to Canada. Your kids are moving to see them. They've got jobs and lives. And, so I
yeah,
think that sometimes people are just very naive as to what these people might be willing to do. So
right.
think about who would be your executor, who would be your guardian. From my perspective, you should always work with a lawyer, but what I'll call the right type of lawyer, an estate lawyer. Please don't just call the first lawyer you find on the street. Make sure you deal with someone who does
Yeah.
this on a regular basis.
Yeah.
And I have lots, we laugh, but I've had lots of people that go to their person who did their divorce or their real estate deal or whatever. And some of those people do wills a fair bit, but a lot of them don't, so if you can, choose an estate lawyer, and there's lots of great estate lawyers. And at IG, we've been giving out names of estate lawyers for years, and we can certainly connect you with people. But it's very, very important that you choose someone who knows what they're doing, and also the key people who are going to be the beneficiaries. How are you going to distribute your estate?
Mhm.
Even
Mhm.
small slights can be taken really badly, so you really want to make sure that you've talked things through and you know what you're doing before you put any pen to paper.
Right. So just to confirm, the executor is somebody that executes your will for you upon passing. The guardian is somebody who looks after your children, potentially if you have them. We have beneficiaries that will receive, the estate after certain things are paid off, such as taxes and debts. Anybody else involved as part of there's three people? They could be all the same. They could be all different too, right? They don't have to necessarily be the same person.
Yes, that's right. I mean, you could technically appoint your, your spouse as well. They'd automatically become guardian, likely, but you could appoint maybe it's a new spouse, so you could appoint your spouse as executor to manage your estate and guardian over your children and beneficiary of your assets. Sometimes you do need to be a little bit careful about conflicts of interest. So if you're going to choose a business partner as your executor, but then they're also potentially going to be buying your business from the estate.
Mhm.
Is there going to be a conflict of interest? So that's why, again, I think you should talk these things through with your lawyer. But yeah, they're different functions, but they can be the same person.
Excellent. Thanks so much for that. Let's move on to the next question. This is very, very important. What happens if I die without having a will?
Well, as I've alluded to, first of all, it will cause a fair bit of stress for your family because they're going to be searching for a will, whether or not they actually find one. I mean, they can't even ask you, do you have a will? If you were around, you could say no, and they would stop looking. But because they don't know, they keep looking, and they look, in safety deposit boxes, under mattresses. People will frantically look for a will for a long, long time.
Mm,
Assuming they don't find one, then they have to usually hire a lawyer and go to court and apply to be appointed as administrator because they won't be able to handle any of your assets. And that includes a spouse. I know there are a lot of
mm,
situations where spouses just assume that they can just walk in and start managing their spouse's estate, and that's not the case. You
no,
can't manage someone else's money. I mean, it's one thing if it's a joint account and you each have authority over the asset. That's a different thing from saying
mm,
I'm just going to manage my spouse's RSP. I mean, the financial institution is going to say, well, no, that's not yours. There's privacy and confidentiality. So you can't really do anything until you've been appointed as administrator. And then the distribution of your estate will be dictated by the laws of your province of residence. And the laws in each province are quite different. The
okay.
surviving spouse usually gets a preferential share. And the preferential share could be a small amount, it could be 50,000. The preferential share could actually be the entire amount of the estate, but they
Hmm,
usually get preferential share, and then the remainder goes to your children often. Again, it depends on every province is different, but there have been situations where a surviving spouse has received, let's say a couple $100,000, which is all well and good, but there's been a significant portion that's gone to minor children, and the clients had assumed, well, we're just going to have everything go to each other because the
mm,
survivor needs those assets to take care of the minor children, except that may not be how things work if the assets are being distributed under the intestacy legislation. Now, again, keep in mind, I'm only talking about assets that pass through your estate. So
mhm.
if you left everything to your spouse through a direct beneficiary designation or joint ownership arrangement or something like that, then your surviving spouse may receive everything anyways. But there are many cases where business owners, assets are in the name of one spouse or another, and they don't want to hold things jointly, and like because of creditor protection and things like that. So each situation is different, and if you don't have a will, it can't, things may not turn out the way you anticipated.
Yeah, it could be very, very messy actually. We talked about spouses and I know this is a whole different conversation, and we'll have that probably in a different session when you have common law spouses, right? But I do have a question in regards to single people. Like, let's just say you are wealthy and um, you have a estate that goes through a will, and you die without having a will. Is that more complex than somebody that who has married and have children, for example?
I don't think it's any more complex necessarily, but there certainly can be situations where things go to people that weren't intended. So,
Mhm.
back in the day, there was, a story about James Dean who died and he was very young, and the licensing from his image, his estate ended up being worth millions and millions of dollars, uh, which basically went to his estranged father, whom he had no relationship with because that was his next of kin, because he was single and he didn't have any children. He may have preferred to leave that to a charity. He may prefer to leave that to, other family members or friends, or, you don't
Mhm.
know because he didn't have a will. Now he was a young person. And as I say, I do think everyone should have a will. But, I've got lots of friends and associates who are single and they don't necessarily want to leave their assets to their next of kin who might be their parents, and think, well, my parents are fine. My parents don't need the money,
Mhm.
versus, a cousin or a niece or someone where it can make a big difference. So, again, keep in mind that the intestate succession legislation, like it's rough justice in the sense that they just sort of have to pick someone and they say, look, here's the map. Here's how we're going to look at family trees. And
Mhm.
if your parents are deceased, then they'll look, okay, well, what about aunts and uncles and nieces and nephews? The money could go to someone that you haven't even been in touch with, right?
Or met.
So, it's straightforward and easy, but it's not necessarily what you would have wanted. It's not
Yeah.
optimal.
Got it. Get a will. All right. Let's talk about children. I think this is close to my heart, anyways. I think we briefly spoke about this, but what happens if both? I mean, if one person pass away, one of the parent pass away, the second one automatically takes over. That's not an issue. But if you have both parents pass away, what happens to children, and are the rules different in different provinces? Actually,
Well, the first issue is, who's going to be the child's guardian, who's going to take care of the child. And if you don't have anyone nominated in your will, then, you can see how that could be a cause for a bit of a custody dispute. I've sometimes had clients say, well, I don't need to nominate a guardian. I've got lots of family. They'll all be willing to take care of them.
yeah,
Well, that could be the problem. One set of grandparents could think that they're better parents than the other set of grandparents, which
right.
happens all the time. And so now you've got children who are orphaned and they're in the middle of a custody dispute.
Hmm.
So, and I've talked to a lot of families through this issue. And, there's all sorts of reasons why people might pick one sort of set of parents versus another. They may say, well, one set of parents lives close by, the kids get to stay in their school and stay with their friends. They love the other set of grandparents just as much, but I want them to be able to stay in their school. Other times they say, well, the ones who live close by, they just medically they can't handle it. It would be more than they could handle.
Hmm.
I'm okay with my children moving to the other province. The other set of grandparents have said, yeah, we could handle it. So, or is it going to go to a niece or nephew or an aunt or an uncle, or who are these children going to go with? So you do need to make sure that you've appointed a guardian. I usually just appoint the family member. I don't appoint the family member and their spouse, because the family member could separate from their spouse.
Wow.
So
Okay.
I usually just say, I appoint the brother or the sister. And obviously their spouse will effectively be the other parent, which is a consideration. Again, sometimes people think, well, why didn't you choose so and so? Well, I like so and so, I just don't like their spouse, right? So there's all sorts of reasons why people do or don't pick guardians, but I usually just pick the one person, and then but I always recommend that you also designate an alternate. So if that first person isn't available, that there is an alternate. But I usually don't designate two people primary and two people secondary. I usually just designate the one person, knowing, of course, that their spouse will be the other parent. So, guardianship is the big issue. But then the second issue is, when do the children get the money? Now, if we're talking about
Yes.
adult children,
Yeah.
then it may be fine. But children, again, it depends on the province, but children will get the funds at age 18 or 19, depending on the age of majority in your province of residence. So, if you are worth, let's say, couple million dollars, and people think, well,
Mhm.
I'm not worth that much. Well, do you have a house? Do you have insurance? Do you have all the, like, things start to add up. would your 18-year-old child be capable of handling $1 million? And, there are a lot of situations where people come from very good families and, the parents certainly try, but if the parents pass away when the children are young,
Hmm.
the children can struggle, they can have drug addictions, they can have all sorts of issues because they're dealing with the fact that they've lost their parents. And there's all sorts of people these days who have these sorts of challenges. And now they've been given this huge amount of money that can actually be extremely dangerous. So we usually recommend that amounts left to children be left in trust until they reach certain ages. So you want to make sure you've got a good executor who can really manage the money well and pay out the money, maybe a quarter at age 25, half of the remainder at 30, some other amount later on. I've actually had parents who've said, I'm not sure, my 60-year-old children, I don't think they're capable of handling
Yeah.
money. So, it really does depend on the situation. But again, you have to make sure that if you want assets to be controlled, then those assets have to go into your estate. And I've had some clients come and they say, I want to make sure that the money is held in trust for 20 years or some long period of time. And then they have everything going directly to their kids by way of direct beneficiary designation or joint ownership, which we usually don't recommend, but
Hmm.
that's what they do. And so the trusts and the will are completely irrelevant. So you need to make sure that you're consistent. Okay, if you want the assets managed by the terms of your will, then those assets have to form part of your estate. If those assets go directly to your children or whomever through a direct beneficiary designation, then saying you want those assets held in trust until they're age 60 is irrelevant. It's going to them
Relevant.
immediately, right?
Yeah. So actually, on this children topic, trust. I know you've touched on this. We hear the terminology "trust baby," whatever it might be. And do you often see people create trusts for their children, and there's certain criterias in terms of wealth and or family consideration that would suggest that okay, a trust should be created, especially for children who are under the age of 18 or 19, like you mentioned.
Yeah, well, I'd say most good wills will include trusts just as a standard part of the will, because as I've said, even if you're not worth anything now, you could be worth a fair bit through insurance, and that there could be some sort of lawsuit or claim, or depending on how a death occurred. So you know it is pretty standard with good wills. I have there's some clients who they go to a lawyer and say, look, I don't want to pay more than $100 for a will or something. They almost walk into a bad situation and choose it.
Right.
And which, there's no document more important in your life than your will. So you do need to think twice before you make a statement like that. You want to make sure that you've got a decent will, but most decent wills will have boilerplate clauses in them. But even then, it may say half at 18, a quarter at 21, the rest at age 22. Well, 22 is still pretty young, right?
Yeah.
So,
Yeah.
what is it that you want? What works for you? So, I think it really is important to make sure that that you take a good look at your will and you talk to your lawyer about it, because even if it might be in there in a standard way, it may not be what you want as in your particular instance. But I would say for the most part, if you're drafting a will, most good ones will have trust language in there.
In there. Awesome. Thanks so much. All right. So what happens now that I have a will? I have my executors, my beneficiaries, guardians, all set up. I know from our perspective, when somebody passes away, we receive the news, death certificate, copy of the will, and according to that, we execute. But how is a will used after I pass away? What exactly happens?
Well, usually what happens is the executor realizes, okay, I have to start dealing with third parties. I have to deal with financial institutions. I have to
Mhm.
deal with the land titles office. And I can't just go in there and say, okay, you know what? I want to transfer all these assets. Let's say you're even the surviving spouse. You
Yeah.
can't just say, go into a financial institution and say, my spouse passed away. Can you please give everything to me? The financial institution is going to say, well, I'm sure, you probably were intended to get some, if not all of this, except for the fact that, there may not be a beneficiary designation, or it may be a non-registered account when you can't have a beneficiary designation. So
Uh,
the financial institution says, well, we don't know. Were you entitled to all of it? Maybe some of it, like what are we supposed to do with this? And we don't want to be liable for making a mistake. So what we need is letters probate, which is a stamped copy of the will, where the executor goes to the court and the
Hmm.
court says, yep, this is the last will and testament of the deceased. Because even if I, as an executor, walk into a financial institution with a will, how does a financial institution know that that was the last will? How do they know that no one's going to make a claim against it or challenge it or say, that the deceased, didn't have mental capacity at the time that they wrote it, or, wasn't properly witnessed or what have you. So to just take a will, and a will can be any piece of paper. That there are people who write their will on a Post-it note. I mean,
Yeah.
that right. So, is it a holographed will? Is it right? Like, is it all in your own writing? So if someone just literally walks into the land titles office with a napkin saying, give everything to my spouse, even then the third party is going to say, well, we just don't know if this is an acceptable will. So the executor has to take the will to the probate court and have it probated. Or if there is no will, they'd have to apply for letters of administration. But because it's a foreign process to most people, they haven't gone through that. We do recommend that you reach out to an estate lawyer and have them help you fill in the documentation, have them help you, apply for probate. And then once that is done, then you can take all that documentation to the various financial institutions or, land titles office, wherever it is that you're dealing. And, even motor vehicles, registration, wherever it is that you're dealing with someone who needs authority, even social media assets. You might need to deal with a company that's got some sort of, authority over, some social media or something like that. There's all sorts of places that need proof of death, and they need to know proof of who you can transfer those assets to. You can't really act on anything without a probated copy of the will. So that's the first thing you need in order, mostly just to get authority to get the assets that you can then start distributing.
That's very interesting. So I'm personally curious about the probate process. Like, so when you get the bill probated, what happens on the other side of the equation? Do they have like the list of all these wills somewhere stored, and they cross check? How do they verify that was the last will?
That's a good question. Yeah. So, first thing that will happen when someone passes away is the family starts rifling around for documents. And it is, for the most part, up to the family, the next of kin, to ensure that they've got the latest will. I mean, if they knowingly take a will that isn't the latest will, I mean, that's effectively fraud, because that there is a later will that says something other than the one that you've chosen.
Right.
So, you are, as executor, you could be personally liable for taking that in and relying on a will that isn't the last will and testament. But when you go to court, the court's going to say, well, is this the last will and testament? Yep. As far as we're aware. So they will probate that. And the reason why probate is a public process is it does allow members of the public to search the registry and also challenge things. So what will happen is, if someone passes away and there's some question as to their capacity, the first thing other beneficiaries are going to do is they're going to challenge that will and say, well, either, the will, there's something fishy at the time it was signed and it's not a valid will, or they may say, look, there's another will. There's all sorts of ways in which a will can be challenged. So the executor needs to be prepared for the fact that when you're probating a will, and there's different ways to probate a will, and one's called proof in solemn form. And solemn form means like you have to take extra steps because it means other people are challenging it. If no one's challenging it, it's usually fairly straightforward. If people start challenging it, then the court says, okay, now we need to, cross a few extra T's and dot a few extra I's. But what about a situation where you honestly come forward with a will and another one comes forward later? That can happen. And actually, that's the reason for probated wills, because third parties like financial institutions, they're going to say, look, we don't want to rely on any will that's brought in, because what if another one is found later, right? So when you get a probated will, you are given authority by the court. Look, to the best of our knowledge, this is the one, go forward. If it turns out that another one comes up later, okay, well, then we might need to fix a few things, but financial institution, you're not liable for that. Like, right. So it's the banks and the mutual fund companies and investment firms, they know, okay, we're allowed to at least act on this will, knowing that we're not going to get sued later. If another one comes up later, then yeah, that's when the court may have to intervene, and they have to figure out, well, maybe we can at least redistribute the things that haven't been distributed already. How are we going to manage this? So that's something that the court will have to navigate through. But if you've got a probated will, you are able to act on it until advised otherwise.
Got it. Thank you so much, Christine. I'm going to ask you one more question, and we're going to move on to the next one. Just quickly, how long does a probate process take, and have you seen it done quick, or does it take weeks and months?
Yeah, that's a bit of a loaded question during pandemic times. Anyways, at the beginning of the pandemic, I really felt for lawyers in private practice. I'm not in private practice, but like they were having a hard time getting anything through the court system, because it was all paper based, and a lot of courts were closed. Like some courts were holding virtual hearings, but that's very different from the law clerks going down to the courts and stamping all the materials. So a lot of things were really, really delayed. And understand, it's not even just the probate process that can take a long time. Sometimes you have to, you almost always have to file a final income tax return, and that can take a long time. So I find that there are some clients who are quite obsessed with finishing off things as soon as they can. And I tell them, well, the first thing you need to do is calm down, because it's going to take at least a year for things to really sort of get settled. And that's if you're on it, right? That's if you're collecting the documents and looking for stuff. Usually nothing is distributed the first year or so. And that's assuming there's no litigation or disputes. If there's litigation disputes, then it could be years, plural. But usually I'd say nothing's going to get distributed in the first year. If you get everything cleaned up within a year or two, then you're doing well. I have heard of a few situations where things were done within a period of months, where things were really, really straightforward. But if plan for the worst, and just don't get it in your head that like sometimes there are situations where people, I swear to God, are ready to spend the money the week after the person dies, which is a little, it's a little uncomfortable, and saying, yeah, it's not coming for a while, so just cool your jets. But there are some people who think everything's going to be divided up right away, and it usually does take months, if not potentially a few years.
Years, awesome. Thanks so much. Question for you. We talked about storage of will and of course, the probate process being a public process, which makes a lot of sense. There's no, will stored somewhere in the basement of the Calgary City Center. But nonetheless, if I have a will, where should I store it, and how, so my family can find it easily? And what about, should I store it digitally or as a PDF format? And then just a third question. I heard the fact that if you have a will that's stapled and you unstaple it to take a scan of it, that could potentially void the will?
Well, if you unstaple it, there's sometimes people who say, well, did you insert another document, or another page? But, usually if you've got each page properly initialed, so you usually sign the end and you initial each page. And if it's sequential, hopefully it would be okay. But yeah, you usually don't want to mess around with the will too much. Now, in terms of storing it, first of all, when you talk about digitally storing it, I certainly would recommend that people have a digital copy of their will so they can review it. And sometimes you need to share the contents with your, financial planner to describe how things are going to be distributed, so your financial planner can figure out how much insurance you may or may not need and that sort of thing. But that's very different from the actual will. There's only going to be one written, one copy with what we call a wet signature, like the actual written pen signature. And that's the copy that the court needs. You can't probate a digital will at this point. There's no such thing as electronic signatures. BC is got some legislation now, and other jurisdictions are working on it. And the pandemic has certainly accelerated that discussion. But for the most part, people are going to have a will that's signed in pen, and that one special copy is what you really need. So for the most part, we tell people, well, store it with your lawyer. Most lawyers have vaults, and they have ways of storing these things in a secure way. Okay. If not, then there's safety deposit boxes, sometimes fireproof boxes in your house. People will they try and protect things, but if you're going to store it in some hidden place in your house and then no one knows where to find it, then it's not of much use, right? So I usually say, in a best case scenario, store it with your lawyer, but make sure everyone knows who your lawyer is. And when I say everyone, in my case, like I've got a list of who my financial planner and my lawyer and my accountant and various people are, and I've shared that list with them. They don't necessarily know all the details of each document, but I've said to the lawyer, if anything happens to me,
here's a clue, follow a trail.
Exactly. So people know who to call, and hopefully eventually they'll say, oh yeah, I've got everything. Don't worry. My parents have this binder in their house, not with the original will, but they have a binder. I know where to find the binder. I haven't looked in the binder. Don't share with me too soon. That's fine. It's your business, not mine. But my dad has said, look, here's the binder. I'm like, okay, got it, Dad. Thanks, that's enough. So everyone's got their own way of dealing with it, but you need to make sure that the people who need to know actually know where to find it, because hiding it so well that no one can find it isn't helpful either.
I'm very happy to hear that your dad trusts you after being a 25 years as state and tax lawyer. That's great news.
I can go there for a while, but yeah, he's come around.
Question for you: when and why do I need to update my will? And is there recommendations on the ways that we should update our will? Are certain circumstances in life that automatically require updating of a will? Maybe time frames, assets, like what are some of the criteria for updating the will?
Well, the first thing I tell clients is, as I said, everyone should have a will. So some people come in without a will. And if you do have one, then I'd say you should have a look at it at least every 5 years, because I've had so many situations where people have forgotten who they've designated as their executor, or, who they've given gifts to. And things change, relationships change, people pass away. When you're younger, it might be appropriate to designate your parents as executor. As you get older and they get older, maybe designating them as executor may not be the right thing to do, because they might not be around when you need them. So, as time goes on, you should be reviewing your will every, I'd say, 5 years. That doesn't mean you need to change it every 5 years. I'm just saying you should review it every 5 years.
Fair enough.
You probably will need to change it whenever you've had a change in relationship status. So have you entered a common law relationship? Have you gotten married? Have you separated? And when I say review your will, I actually would say review your estate plan, because there are many people who they get separated and they pass away 20 years later, and they still have their former spouse designated as the direct beneficiary of their $1 million life insurance policy, even though they've got a new spouse by that point, right? So anytime you enter or end a relationship, you should review your estate plan. But, obviously your will would be the first place to start. If you've had any sort of significant event, like an important time to make sure you have a will is if you have a beneficiary with a disability, because you want to make sure that there's certain clauses in there and certain protections in there. So, there can be other situations where updating your will is important from a planning perspective. So I would say every 5 years, unless you've had a major life change. One thing I would say, though, is I wouldn't make too many changes if you have grandchildren. I find that a lot of clients, for whatever reason, when they have grandchildren, they temporarily lose their minds and start, giving hundreds of thousands of dollars to these 2-year-olds, which is usually not a great idea. So I also want to be a little bit careful about how often people change their wills, because actually I think gifts to grandchildren can be incredibly dangerous. And I would wish that people in some cases would just leave things well enough alone. And that's why, to answer your second question, I usually don't recommend that people change their will unless they go to their lawyer and make sure that what they want to do actually makes sense. Because a lot of people, they're well intentioned, but leaving $100,000 to a 2-year-old isn't a great idea. Especially when they could have siblings later on and they won't get that same amount of money, right? So it can cause a huge amount of strife in a family
Mm.
if, again, even a $10,000 gift, a small amount can really cause a lot of grief if different grandkids end up with different amounts. So I do recommend going to see a lawyer. And a lot of times people say, well, should I draft a codicil? No, it usually is. I mean, that's a really old fashioned thing to do. Everything is now online, even though the actual will, as I said, is still printed off on paper and you sign it.
Mhm.
The
Mhm.
will itself is online. So if you want to change something, like if you want to change the executor, just go to your lawyer. They'll take out one name, put in the other, print it off. You got a clean copy.
Yeah.
You're good. It's actually harder to draft a codicil because they have to say, okay, we'll change this word on this line. Like it's custom drafted then, right? So then
Right.
you have to have your will and your codicil. It's usually just easier to print the thing off again.
Two questions for you on this topic. Number one, children. I have two kids. I have a third one. Do I update the will?
Usually it depends on the terms of the will,
Parents.
but usually the will say I, leave my estate to my children equally, as opposed to I leave my estate to
Uh,
Jill and John, and now you have to add Jack.
right.
So, if your will says I leave my estate to Jill and John equally, and then you have Jack, then you have to change it. If it's generic and it just describes your beneficiaries by a class, then you may not need. So if you say children and now you've got, and that's what happens with grandchildren. And that's why gifts to grandchildren can be so dangerous, because sometimes grandparents will say, I want to leave $100,000 to be divided among all my grandchildren. And when they die, they have one grandchild. Well, but then 6 more are born later, but they don't get anything because the 100,000 went to the first one and then the others don't get anything. Right.
Yeah.
So
Yeah.
it really depends on how things are drafted, but hopefully it's just by a general description.
Okay. Last question for you on updating wills. I have my stuff with RBC, and I decided to work with Hash Assad and transfer all my money over to IG Wealth Management, including creating a bunch of new accounts. Not only up to my will, do I?
Again, that depends on the situation, but I would hope not. Because usually you don't refer to any specific asset in your will. So you don't say, I want to leave my 2019 Honda Civic to my spouse. You just say, I want to leave my estate to my spouse. So if you sell the Civic and you buy something else, you're not going to change your will every time you update anything. Unfortunately, I have seen some people, though, who have said, I leave RBC account number 12345 to this
Yeah.
specific beneficiary. And
Yeah.
that is a dangerous thing from 1,000 reasons. First of all, you could change the account. RBC could change it to 12345 to 78910. Like, and even at IG, we've changed
Yeah.
names of accounts and numbers, and
Yeah.
that people withdraw. So some people start off well-intentioned. Oh, I have 3 accounts with $10,000 in each. I'm going to leave them to each of my 3 grandkids. They take all the money out of one, leave the others in 2. So I don't recommend that people do refer to specific assets in your will, but
Mhm.
if they have, then changing the nature of your account might necessitate changing the will.
Fair enough. Thank you so much, Christine. All right, let's get into it. Doesn't matter where I live. I know Canada, many provinces, many different rules and regulations. Are they similar, or does it make a difference? And if I'm in Alberta, I have a will, and I move to Ontario, do I get a new will?
Again, usually not. But what I will say is, if you're moving to a new jurisdiction, like how far away are you moving? So if you move to the States, are they going to accept an executor appointment of someone who lives in Canada?
Good point.
So that's one issue. Sometimes people will do a holograph will, which again I don't recommend, but some jurisdictions do accept holograph wills, others don't accept holograph wills. And I think the bigger issue is if you move to a jurisdiction and you didn't have a will, because in some jurisdictions, common law partners receive the entire estate, and other jurisdictions, common law partner 30 years doesn't receive any part of the estate. So some people assume that all of our laws are exactly the same across the country, which couldn't be further from the truth when it comes to property law. So anything to do with estates, family law, division of assets, that sort of thing. So I do think that moving jurisdictions is a good opportunity to review your will. And as I said, when you have a major change in life situation, that's probably a good time to review it. but it's possible that you don't need to change it. But if you're moving, let's say that you're moving to Quebec, they have notarial wills, right? So that may be a situation where, it's worthwhile speaking to a lawyer, and lawyer may say, you know what, we should print off a new one, draft a new one that meets the conditions for Quebec, and it usually is an opportunity to update your estate plan when you move jurisdictions.
Excellent. Highly, highly recommended if you do end up moving. You mentioned a few different wills in here, a different terminology, holographic. Like what are, I know a mirror will, maybe you can explain to us what that is. Other types of wills that we should be aware of. I know you said, back of the napkin, write down where you want your assets to go to. That could potentially work as well. So what are some other types of wills besides going to a lawyer and getting one written the way we described it so far?
Yeah. So holograph wills are wills that are written completely in your own handwriting and don't need to be witnessed, but they do need to be completely in your own handwriting. So there used to be, will kits, at the grocery store, and half of it would be printed and half would be in your own handwriting. And then people wouldn't get them witnessed, and then you'd have a problem, right? Because it has to be all in your own handwriting. A mirror will that you've asked about is when spouses have the exact same will, but they're a mirror image of each other. So the husband leaves everything to the wife, or the wife leaves everything to the husband, and then to their kids. And so they're not exactly the same will, of course, but they're the mirror image. A mutual will is when spouses leave everything to each other and indicate that when the survivor dies, they cannot change their will. It's like a contract. Sometimes people in second or third marriages use those. We don't recommend them. We find them to be very messy. For blended families, we usually recommend other strategies. And I will say, if there's one situation that can continually cause huge amounts of litigation, it's people who are in blended families. So people who have children from a previous relationship, and they don't think about things, and they just leave everything to their new spouse. And then when their spouse dies, the spouse leaves everything to their kids, just because that's what the will says. And people don't think things through. So what sometimes people do is they say, well, I'll leave everything to each other, and then in the second death, everything has to be divided by both families. But then one spouse dies, and they says, okay, well, what happens now? I want to sell my house. I want to change things. And it's just a recipe for lawsuits. So we usually say, okay, we'll leave part of your assets to your new spouse, part of your assets to your kids from a previous marriage. If you don't have enough assets, consider insurance, but divide the assets at the first death. Don't use the mutual will. So sometimes there's no choice because people aren't insurable, but mutual wills can be extremely litigious. In some jurisdictions in Canada, there might be a reference to multiple wills. So sometimes business owners use one will for shares of a privately traded company versus other assets, and that's strictly a probate saving thing. So in Ontario, that's pretty popular. So there are other types of wills like that, but for the most part, when you're just talking a standard form will with the two signatures, that would be what most people would get in their with their lawyer, and potentially a mirror will if they're going along with their spouse.
Awesome. Thank you so much. Let's talk about creating a will. We kept talking about, a lawyer to get a legally valid will. Do I need a lawyer to create a will?
You can technically create a will on your own without a lawyer, but we do not recommend it. Just every will I've seen that people have tried to create on their own, it's usually a recipe for litigation. And irony is, people say they don't want to go to a lawyer because they want to keep things simple. And then when they start drafting their own will, they make things very, very, very complicated. And so, for example, I generally tell people, try to avoid specific gifts. Like, try to avoid, saying, with parents, they say, okay, I want this piece of property to go to this child and this piece of property to go to another child. Well, that can cause huge amounts of litigation because each property is worth a different amount, or the parents sell one property, so one child gets nothing and the other child gets this huge, property. Even if it's a small item, it can cause huge amounts of issues. I've already talked about the problems with leaving gifts to grandchildren. So usually I say, well, unless there's a specific reason, consider, if you leave it to each other and then divide your estate in portions. And, you may want to leave a portion to a charity or something like that, but, 25, 25, 25 to each of your three kids, and then 25 to charity or something like that. But what happens is when they go online and they see these wills, and because they're just programs, the program says, do you want to make any specific gifts? Well, they start giving away all these gifts, and including, the 2019 Honda Civic. And then they die 20 years later. And the person who's supposed to get the 2019 Honda Civic says, where's the Civic? Well, they sold it 15 years ago. Right. So, those are the sorts of things that can cause a huge amount of grief. So you can do it on your own, but I do not recommend it. The other thing is people will print off the will and they'll get one of their beneficiaries to witness it. Well, you won't inherit anything if you're a witness, because witnesses, there's a conflict of interest there. So usually you have to be signed by the witnesses can't be beneficiaries or even spouses or common law partners of the beneficiaries. Usually, again, it depends on the jurisdiction, but so someone will get their daughter-in-law or son-in-law to witness it, and then they can't, the child still can't get anything because maybe the will won't be valid or something like that. So make sure it's properly witnessed. Do you have an affidavit of execution? That's one of the problem with online wills right now. The will themselves might be fine. They print it off and then they get it witnessed by a neighbor or something like that. But then you still have to go to the lawyer and get the affidavit of execution. So, I say, why didn't you just go to the lawyer in the first place? But, I know there's some people, for whatever reason, are quite insistent on doing it on your own. You can do it on your own, but just beware that it can cause, and in fact, I've told many people, in many cases, you'd be better off dying without a will, because then at least it's pretty clear how the estate will be distributed. May not be what you would want, but at least it's clear. It's when people are drafting things on their own, and the stuff people draft, like I don't even understand it. I say, so what did you mean by this? We have no idea, right? And they use language that courts have never seen, the case law is never interpreted. It's just sort of Wild West. So I do not recommend it, but you can do it technically.
Fair enough. You actually answered this question. So if you are one of the beneficiaries in the will, you cannot be the witness. So you said the neighbor could potentially be the witness? Like, who would you recommend to be a witness here?
Well, hopefully your lawyer and if someone else, one of their associates, hopefully people who are not at all involved. And so there's no, inference of undue influence or something like that. Because again, you can well imagine if a parent does a will on their own and they leave all their assets to one of their 3 kids and that child is the beneficiary or is the witness, you can see why the courts have said, that there's a problem with that, right? Because it's the undue influence and coercion that courts want to get rid of. So hopefully it's a lawyer and someone else at the lawyer's office. But if not, then, someone who's not a beneficiary or spouse of a beneficiary. Now, there are some ways where you can fix a situation where the wrong people are witnesses. If you have, hypothetically, let's say you have 3 or 4 witnesses, as long as you have 2 who aren't beneficiaries, sometimes the courts they'll just ignore the extra witnesses, so to speak, right? So, but for the most part, it's best if you have an independent third party acting as witness, who's not themselves going to profit from the estate in any way.
Fair enough. I think we already answered this question. Can I digitally sign my will? I think BC is the only province that's either implemented it or considering implementing it. But I think the rest of the provinces are no. And I think you mentioned the fact that it could be stored digitally, scanned, sent to to your financial advisor, to the executor, to the guardians, so at least they know what to expect.
Right. Yeah. I think it's worthwhile to have a copy of it so people know what it says. But usually what people will have is they'll have the draft that the lawyer sent to read it. They won't necessarily have the signed copy stored digitally. As you said, do you want to rip the whole thing apart, take out the staples? And, so usually the hard copy, signed copy is with the lawyer, and the digital draft is what people would work from. But it's only BC right now where you can actually digitally sign it. During the pandemic, a lot of emergency laws came into place across the country where you were allowed to sign the wills and sign and witness the will in a different location, because usually you had to all be in the same room. So there are varying laws now about how you can witness and sign a will, but really you can't digitally sign it, and you can't digitally submit it yet, except in BC. Now that could change, but I know that there's a lot of concern about fraud and stuff like that. Oh, you could fraudulently sign a will too, right? So
Yeah. Yeah.
got to make sure that it's done properly.
Fair enough. Awesome. Um, any things after I've created my will with a lawyer, I have a copy of it signed. I'm assuming the parties as part of my will should get a copy of it at least. But anything else I should be doing with that will document?
Yeah, I mean, you can give your next of kin a copy, but you don't have to. Although I think sometimes people say, "Well, I don't want my family to know how much I'm worth." Oh, don't worry, they won't, because the will won't say. The will's not going to know what you're worth. It's not going to have a list of your assets. It's going to say,
Yeah.
"I want you to divide my estate to be between my two kids." Well, surprise! Like they probably would, we're expecting that. Now, of course, if there's some other surprise in there where you say, "Want to leave 90% to one child and 10% to the other," that's where people want to be much more private about it. But yeah, whether or not you share it, you should at least, as we've discussed, share with people where you've stored it, so that first of all, it is stored in some place secure, so that you're able to find it when you need it, but people know where to find it. I do think it's important to make sure that your entire estate has been taken care of. So it's not just your will, but also your power of attorney, your beneficiary designations. You should make sure that you've spoken to the people that you've designated, hopefully even before you sign the will, who's going to be executor, who's going to be guardian, that sort of thing. But the main thing is to make sure that it's properly stored and people know where to find it when they need it.
Awesome. Let's talk about this. Okay, so when I first started out a long time ago, we talked about the will kits that you could buy at the registry. I don't think I've been to registry for a long time, and I don't think I've seen them for a very long time either. I think they've all kind of disappeared. We were told that these will kits were intentionally created by lawyers to allow people to create their own wills, and it's cheaper for them to create these will kits. You buy for $50, make a whole bunch of mistakes, and then they have to show up and fix it, and they make a lot more money. So
Right.
let's talk about the will kits and your thoughts on living in 2022 digital world. A lot of websites here in Canada who have now the capacity to create wills at much lower costs. Good, bad, avoid.
Yeah. So actually, as it turns out, I have recently done a review of the online will providers just to see what was out there, because traditionally, especially with the hard copy wills, our advice was do not use them unless you hate your family and you want them to have to go to court and litigate. Do not use those will kits. But I will say that the online wills that I've seen, there are more guardrails in them, in the sense that, and I've spoken to a lot of these providers, and they're very thoughtful. What they're trying to do is make sure that the average Canadian can have access to a will at a reasonable price, which is fair. But and they've acknowledged that, look, these will kits are not for everyone. So they do ask some questions before they even let you get into the software. So do you have a beneficiary with a disability? Yes. Okay, don't use this, because it's just there's some complications there. Do you have a child from a previous marriage? So is there a stepchild? This is the blended family. Yes. Okay, don't use this, right? Like, this is not for blended families, because that gets complicated really quickly, right?
Yeah.
So they are taking steps to make sure to identify for people when they've got complications, because I've spoken to clients and I've said, okay, so are there any complicating factors in your scenario? Nope. Oh, then I start asking, certain questions. Is there a stepchild? Yep. Is there anyone with U.S. residence, U.S. citizenship? Yep. Do you have a business? Yep. So they don't think they have any complication in their lives, when in fact they're in their third marriage and they've got kids from 3 different relationships, and it's super complicated. So clients sometimes need you to identify what the complications are. And
Right.
these will kits have done a better job of that. Now, if you're in a straightforward scenario, though, where you don't have any complications, I think that we're in a world where it may be easy, it may be okay to use these online will kits on occasion, but you're not getting any advice. And so,
Right.
you see people who designate a non-resident as their executor, or they do start making direct gifts to all sorts of people, which, just makes things super complicated. They don't get them properly witnessed. They don't get the affidavit of execution. So the online will kits are better than they used to be, but I still don't think that they're as good as what I'll call a good lawyer. Now, the irony, and I've spoken to, there's a team of us who've looked at these online will kits. If you use a bad lawyer, you would be better off with the online website. So
True.
the bad lawyers who don't give any advice or give bad advice, that's probably one of the worst scenarios. And some of them just use these wills from 50 years ago. There's people who are practicing who should have stopped practicing many, many years ago. They don't keep up with changes in the law, and the wills are awful. And a lot of these online wills are actually quite modern when they talk about digital assets and stuff like that, and the things that you need to have in your will now, right? So if you're going to a good lawyer, that's the best scenario. If you're going to a bad lawyer, that's a bad scenario. If you're going to a good online website and you've got a simple situation, that might be okay, but you still have to follow all their instructions. Okay, who can be a witness? Do I get an affidavit of execution? Have you followed all the steps and crossed all the T's and dotted all the I's? And a lot of people just don't want to do all that stuff. So beware. That's all.
Yeah, I think the creation of the will and the challenges that I've experienced with my own personal clients over the years has been it's time consuming. It is a little bit intimidating to be in front of a lawyer, talking about these different things. Cost is a big factor as well. Don't get me wrong, spending $1,500 on a will save you thousands of dollars on the road, but still you got to fork out, $800-900 for a will and a few other documents. So I think we're at the spot where we need every adult Canadian to have a will, but also make it easier somehow for them to get it. And I don't know what the right combination is between online and going to a really good lawyer to do this. But it'd be interesting to see how this evolves over time, and we overcome the challenge and have every adult male in Canada or female in Canada to have a written will.
Yeah, well, it would be great if everyone had a will, but I think what's even more important is you want everyone to have a good will. And we offer a service to our clients that, our high net worth clients that, will review wills in certain scenarios. And no matter how much money people have, it's amazing to me. I've never reviewed a will and had nothing to say. Like, they're all slightly out of date and I'm like, usually, and I don't want to tell people how to leave their estate, it's up to them. But I say, so, you've done it this way. Is that what you intended? No. When you talk it through to them, so, because in order to review a will, we also need a bunch of background information. So I'll say, you've got 6 grandkids and you've named one as one grandchild as receiving a gift. So did you want to leave less to the other 5? No, but there's so much that's unintentional because people, they don't review their will regularly, or they don't spend enough time doing it properly. And I do think it's important that you review your will and get it updated by a lawyer where possible, because it can cause, there are families, they've been ripped apart forever because of, in some cases, you can tell it's just a complete oversight in the will. There was nothing intentional. It's just the parents didn't think about it, and the kids aren't going to fix it by, redistributing things. And all of a sudden people aren't talking to each other. It's very tragic.
Very tragic, exactly. All right, let's talk about a couple other pieces of documents in addition to having a will. Power of attorney is a piece of document that you should have to assign somebody to look after your financial affairs. And PD we refer to as personal directive. Also another piece of document that you assign somebody to look after your health affairs. What are these, and are they just as important to have a will, or could you just have a will, not these two documents? What are your thoughts on those?
Yeah. So personally, I think the power of attorney is the most important document in your estate plan. As I've said, if you die without a will, there is a distribution in the intestate succession legislation that sets out how your estate will be distributed. It may not be great, but there's a roadmap there. If you don't have a power of attorney and you lose capacity, then it is really tough. And now your next of kin have to go to court, and they have to be appointed as committee or guardian. And they will need authority in order to start managing your assets. And you will, may have to prove incapacity. And it's very difficult. Personal directive, as it's known in Alberta, the more generic term would be a healthcare directive. So a directive that deals with healthcare concerns versus financial concerns. that is the document out of the three that I see the least. That doesn't mean it's not important, and some people have some very specific preferences regarding healthcare. But that's a document that I actually think you should review with your doctor as opposed to your lawyer, because sometimes I've heard doctors say, well, these directives, they use language that doesn't mean anything to me. And so sometimes family members don't want to hear what the directive has to say. So like, I'm going to hide that directive, so you should talk to your next of kin, because usually it's your next of kin in case of emergency that are going to influence what kind of care you would or wouldn't receive. Because if you don't have capacity, it's going to be your spouse, your children who are saying, yeah, I do or don't want you to, prolong life. So that is something really, that's a discussion you need to have with your doctor. You should have with your next of kin. And yeah, sure, having something in writing would be good as long as it makes things more clear as opposed to less. But the power of attorney for finances, that's absolutely something that everyone should have, because you never know when you're going to lose capacity, even temporarily in an accident or something like that. And it's a key document.
Very interesting. So just hierarchy-wise, power attorney, will, and then personal directive.
Yes.
Awesome. I think we briefly touched base on this, the type of assets that can potentially bypass your will and bypass your estate, and then no name and direct beneficiary on an RSP, RIF account, tax-free savings accounts. But there's only a few that I can think of where it will not have to go through your estate and therefore directed by a will.
Yeah, so there's a few ways that assets can bypass the estate. So if assets are held in joint ownership with right of survivorship, then the asset will go to the surviving owner. And there's no right of survivorship in Quebec, by the way, but in the common law provinces, you can hold assets jointly. I usually don't recommend joint ownership unless you're dealing with a first marriage scenario. But there are people who add their kids on as joint owners. It tends to cause nothing but confusion and again, a lot of litigation over jointly held assets. But especially when the children separate or divorce or what, like it's just can be a huge mess. So I'm going to repeat it. It's do not recommend joint ownership in most scenarios unless you're in a first marriage. But joint ownership is one way potentially. And then direct beneficiary designations, which are in Quebec, only legal on insurance policies. Outside of Quebec, it's insurance, RSPs, RIFs, TFSAs. So those assets could go directly to a beneficiary. But again, that can be very dangerous. So sometimes people will designate one of their three kids as direct beneficiary of all their assets. And I'll say, so why would you do this? Oh, to make it easier. So it's easier now that it goes to just one of your three kids. Oh, well, my will says it's to be divided in three. Those are relevant, Oh, they'll share. Okay, I'll just leave that alone. I read the court cases that come through, and there are many families where, trust me, they don't share. So, direct beneficiary designations and probate planning has been the cause of an unbelievable amount of litigation. And the irony is, in some jurisdictions, like in Manitoba, our probate fees are now literally zero. In Alberta, the maximum is $525. I mean, effectively zero. I realize that the size of the estate can impact the legal fee, but that's something you negotiate. I think this whole probate planning scourge, I'll call it, has just caused so much grief for families. And I really think that people need to think much bigger picture. Probate planning really, people want assets to bypass their will, but then they are complaining that, when I explain to them, well, look, your will has all these things you wanted in it. It's got a trust in there for a beneficiary with a disability, and it will allow them to keep receiving social assistance payments. You're not going to get that anymore. You know that, right? Well, I want that. Okay, well then have assets pass through your estate. So which is it? Like, what's most important? Saving a couple $100 in probate or having your estate properly distributed? I find that the probate thing it's just taken on a life of its own, and it makes no sense to me. I just don't recommend it most of the time.
Awesome. Let's talk about your final thoughts about the will. Anything that you want to share with us from your 25 years of extensive experience and having to deal with this firsthand. You probably know more than anybody else within our company in terms of do's and don'ts.
Well, I think the first thing is to just get started. I think sometimes people think if I don't decide now which of my children is going to receive every piece of Tupperware in my house. I can't do anything. And people just, they start writing all these long lists. And sometimes I almost disappoint people by saying, you realize you're actually not going to be making any of those decisions, right? You're going to be saying, look, I want my estate divided in 3, but the executor, probably with the kids, they're going to decide how that third gets divided, right? And actually that should come as a relief. Sometimes parents say, oh, no, I'm going to decide. I'm going to decide who gets which piece of property or whatever. I said, okay, how do you think that's going to work? Because, with kids, if you give one the blue truck and one the red truck, the one who got the red one wants the blue one, the one who got the blue one wants the red one. As a parent, especially when you're dealing with grown adults too, you don't want to dictate too much. You need to let them pick and choose. So really, it's not about making every tiny, minute decision. It's about making the big decisions. So who's going to act as guardian of my children? Who's going to be executor? How am I generally going to divide my estate? Do I have charitable intentions? Do I have something specific I need to plan for, like a beneficiary with a disability, vacation property, a farm, a business, that kind of thing? Think big picture and work with an independent third party like your financial advisor, your lawyer, maybe even your accountant, to help you navigate through these problems. Because sometimes people make up problems. They say, well, I'm concerned about such and such, and say, well, that's not even an issue, right? These people have these ghosts and goblins in their head, or they don't know how to approach things, and they're only talking to family members who have various biases. So work with an independent third party who can help you navigate through some of these things and provide solutions. And there often are solutions. Sometimes people say, well, I don't have enough assets. Well, that's because you don't have enough insurance. Some of these things can be pretty easily fixed. But if you never speak to someone who actually has any, experience, people will just go in circles. Social media can almost be dangerous.
Right.
Regardless of what we're exchanging in right now. But I mean, there's so much information online. I think that people get confused and overthink it, and then they almost get paralyzed. And what you really need to do is just get started, talk to your trusted advisors, and take one step at a time. And eventually you'll get where you need to go.
Appreciate it. Thank you so much. Listen, folks, thank you so much for making it so far. We hope you found this informative to help you make decision and the importance of having a will. If you have any questions, anything that you wondering about, asadwell.ca, email me directly, hash.asad@igpwm.ca. Now, you made it this far into the presentation. I wanted to share a small bonus guide with you. This will be available in the description below. So please go ahead and download it. This is our estate planning guide. We spoke about just one section of it. Why do I need a will? But there's so much ground Christine has covered in this document, from personal representation, gifts to your children, blended families, common law separation. There's 16 pages of excellent data here. We'll leave that for you, but also stay tuned. We'll have another session with Christine and deep diving into some more aspects of estate planning and why it's so important to address these issues. Thank you so much for joining us. I hope you found this informative. We'll talk to you soon.